A thread by Ron Coleman in a response to Econ Chick Intel Chick. Econ Chick Intel Chick says, this may be a little premature, but that's what I would guess too. SCOTUS rejected the Kelly suit from Pennsylvania, but then put the Texas suit on the docket. Ron Coleman responds, docketing is just a rubber stamp. This, on the other hand, fourth entry down, is a scheduling order. And the same friend who sent me that writes as follows, quote, that scheduling order is not automatic. It's specific to the relief sought. I predicted the Texas suit in November. I'm following everything, more than you can imagine. Look at my search results from November. November 21st, visited Article 3, United States Constitution, U.S. law. Visited jurisdiction, original Supreme Court, federal. Visited about the Supreme Court, United States courts. Searched Supreme Court, original jurisdiction, Constitution. Remember that phrase, original jurisdiction. Back to Ron Coleman's friend, quote, Trump said his lawyers told him he, quote, didn't have standing in a, quote, big, beautiful suit that covers everything back in November. Now, what lawsuit on God's green earth would be comprehensive but not allow the candidate for president to have standing? Answer, this one. You can only get original jurisdiction in the Supreme Court of the United States, SCOTUS, in a dispute between the states. Original jurisdiction as opposed to appellate jurisdiction, meaning if it's original jurisdiction, you go straight to the Supreme Court without ever having to go through a lower court. The only way to have one big, beautiful lawsuit where a court has jurisdiction over all states is in SCOTUS. So a state could file the big, beautiful lawsuit, but the president cannot. Only lawsuits by states against states qualify for original rather than appellate jurisdiction in SCOTUS. That is why his lawyers said that he wouldn't have standing. For those of you just listening, there's now a screenshot of Business Insider from November 20 something, 2020. Hang on. Sorry, guys. From, I can't read the date, not even with my reading glasses. Sorry, it's too dim. But the headline is Trump wanted to file one big, beautiful lawsuit claiming election fraud, but says his lawyers told him he didn't have legal standing. Back to Ron's friend, quote, that didn't make sense to me, so I researched it. That's when it made perfect sense. And that's been the plan all along. You think it's coincidence that Texas files midnight before SCOTUS was to consider Pennsylvania's case? No way. And Alito doesn't dissent when he already said what Pennsylvania did was unconstitutional. Once this case was filed, SCOTUS got the message. They deferred on Pennsylvania, just on the injunction request, to knock out all four. Notice also regarding the big, beautiful lawsuit that his lawyers did not say that there is no court in which to do this. They said that he does not have standing. As I've learned, following Trump closely all these years, he's always saying things that sound ridiculous at first, but are very much grounded in reality. End quote. Thus ends my friend's DMs. We're back in Ron's voice now. I nipped and tucked a bit for the sake of the threading. You can take it or leave it. But it answers a few questions. One was the Alito question, and I just gave the same answer privately to someone myself. Alito may very well not have changed his mind about the issue. Indeed, I believe he is making a stand here in a way that he never has in his judicial career. If this is right, he did not change his mind about the legal ruling, but may have changed his mind about the case more. As has been pointed out elsewhere, however ancient and obscure, there is precedent for this procedural approach in SCOTUS, and that court loves precedent. Also, this lawsuit, at this hour, draws on all the information, evidence, data, and legal missteps of the previous cases, the ones that were savaged for their errors and sloppiness because they had to move first and fast against the institutional current and the state hearings. Moreover, that this lawsuit was filed by Ken Paxton, Attorney General of Texas, helps me understand a cryptic remark by a friend in recent days, which I cannot share with you, unfortunately. And you know my life is otherwise an open book here. And finally, this. I know this will cost me, but hear me out. For weeks, I have been watching Thomas Richter's videos. Flattery will get you everywhere. And I flinched each time he said one particular formulation. Quote, when the Supreme Court sees this evidence of widespread fraud, oi, I said each time, slapping my forehead. Why does he say that? He means when they review the record of fraud in the lower courts. You can't introduce evidence in the Supreme Court. And damn if every lower court so far has refused to let that evidence be heard. Well, I'm not saying Thomas knew it, but I'm just saying there is a time when the Supreme Court can consider evidence in the first instance, when it hears a case in which it has original, not appellate, jurisdiction. There's pretty much only one kind of case like that, and that's the case I woke up to this morning.
Click.
I will be
Click.
the greatest president
Click.